So,
Imagine
main
a
point.
lawsuit where you have had, let's say, 5 interlocutory applications here and there, and then sometimes imagine one or two have gone upstairs on appeal. That has a
Mm-hmm.
way of, sometimes you ask yourself, what are we even, what is even the fulcrum of this case? Because from
Exactly.
one lawsuit, we have seen a lot of law reports from one lawsuit. One is talking about a different subject matter. At the end of the day, the question is, what even brought the parties to court? Sometimes it is easy to lose sight of these facts. This is because we are humans, the human element is there. And even the Supreme Court warned us and said that the Supreme Court is final, not because it is infallible, but it is infallible
Mm-hmm.
because it is final. That
I
speaks
know.
to the fact that we are subject to, so we cannot make excuses for ourselves and then also not consider that the judges who sit over our matters are also human beings, right? So this is not to make any excuses for anything, but it speaks to the fact that bringing things to perspective at every point in time helps to helps the other person to understand our point of view.
Thank you very much for that explanation. So let's demonstrate. Let's go right into the. We've done the theory part. Let's do the practical now. So to make this easy, we've agreed on two scenarios, ahead of
Okay.
time, and
Okay.
you have agreed to to adumbrate on a um, a final address in a breach of contract matter, and
Okay.
then on a written address in support of motion for substituted service. So I've done it this way to show that adumbration is not just for the final part leading to judgment. It could also be on a written address leading to a ruling, so that it will be clear to whoever is watching. That's why I want to do two scenarios, just like we did in the first part. So I'll leave you
Okay.
to start from whichever one, and then you can just paint
Okay.
uh, uh, an imaginary scenario, just to give us
Okay.
context.
Okay. Okay. So just before I delve into that, I wanted to add that the rules of court,
Mhm.
knowing the value of providing clarity, provides for time for parties to clarify, argue. So it's different from, so you can, I don't want to, time for parties to provide clarity. So like you
Okay.
have the rules of court, of the High Court of Lagos, or that's 35, Rule 4, thereabouts, provides for oral argument. After, so oral argument, after you have settled your brief, the Court of Appeal
Okay.
rules also makes provision for that. So in the High Court of Lagos, I think it's about 10 or 15 minutes. Court of Appeal, I think it's about 20 minutes or thereabout, or the other way around. So, but it speaks to something. It speaks to something of how important it is for you to draw that clarity and, make the distinctions where we need to have those distinctions.
So
So with that said,
have you just said that there's a legal backing for adumbration? I'm asking because
yeah,
would that then mean that if a party wants to adumbrate and the court then says it's already in your written address, let's go on, don't waste our time and all of that. A party then say, "My lord, I have the legal right to actually adumbrate, so I would like to use my 15 minutes or something of the sort." Is that what you have said?
so, the court is the one in charge, the judge is the one in charge of his court, at every
Yes.
point in time. So it can be discretionary, considering the load of tasks on the court per time. So, but how be it, the a solicitor, an advocate rather, can urge the court, right? Particularly when you believe that there are issues that have become muddled up by how boisterous the litigation, the lawsuit may have gone. So,
Okay.
for instance, you have examination in chief, cross examination, and re examination. So, if you feel that your case has been completely or significantly messed up by the reason of convolution of facts, because of some responses that were